So welcome to this year's NYU reunion. It's 2022. And today's event, which is called The Many Facets of Public Policy in International Arbitration, is actually an event, the idea behind of which comes from the three speakers whom you will see, Alessandra Franchi, Judge Fabienne Schaller, and Fabio Trevisan. They are all from the class of 92. So this year is your 30th reunion. Thank you for being with us. And thank you, of course, for putting this together. Thank you also for inviting me. This being said, the idea is to give the floor first to Alessandra, then to Judge Schaller. I will then speak as the third speaker, and Fabio Trevisan will actually conclude. We should have enough time at one point to answer questions. And believe me, if we do not have questions from your side, I think we will not agree on all of it. So it may well be that we will ask each other questions. So without further ado, Alessandra, I wonder whether you could first introduce yourself, and then you have the minute for your talk.
Yes, good afternoon, everybody. I'm Alessandra, I'm Italian, and as Franco has said, I attended the 1992 LLM class, and very happy to be here and to present this panel with Fabienne, Franco, and Fabio. And I am working for the European Commission, which is a European institution based in Brussels, and particularly I work for the Directorate of Competition, and we are also directly involved in some of these arbitration cases, and that have been brought before the European courts that I will tell you about today. And we've been, especially my service and myself, we've been participating directly to the hearings held in Luxembourg during the year of 2020 and leading to the Mikula judgment, which we will then go into details. And so have discussed directly with the judges at the hearing all these principles. And so we here really providing you our own opinion. But first of all, let me just a disclaimer say that this is my personal opinion, even if, of course, we've been defending the Commission position in courts. But what I'm saying here all today, it's just my personal opinion, of course, does not engage the European Commission. But so going into detail, just as we are four, and we will speak on different subjects, which are all related to arbitration and to the issue of public order, and so very, very, very interesting notion. But let me just focus and limit my presentation to a specific field, which will be EU law and arbitration, ICSID arbitration. So to that extent, what I would like just also to introduce is the fact that the recent case law adopted by the European courts in Luxembourg, they have recently attracted considerable attention because the European Commission related to the European Commission use of the state aid rules, and as probably most of you, or some of you, but not all the American knows that we have a specific system of European rules which are related to the subsidies, the states that the member state can give to their own enterprises, and those subsidies, they can be given, but they are under strictly rules, European rules, which are in the European Treaty. So just to go that there is, in fact, the fact that so the Commission was enforcing their own state aid rules, and that it is also by applying those rules, which are really different in the American system, of course, because before giving subsidies to specific enterprises, the Commission so has to intervene and authorize the state aids. So has to authorize the member state to give the company specific subsidies. And in that interference, of course, by doing that, by judging on a specific, like in the Mikula case, a specific state aids that have been given to companies, of course, what happened is that the Commission made what has been called an unprecedented kind of incursion to the world of the investor state arbitration. And that's why. And of course, these are two different separate legal regimes. And on the one hand, we have ULO, state aid rules. On the other hand, we have arbitration. And we will see especially international treaties between the state relating to the investor protection. And those two legal regimes, they have coexisted for years. That's for sure, that we have to admit that. And to a certain extent, it is surprising that there has been a little jurisprudence and case law, let's say up until now, on those relationships, and that only in the recent years, and especially from 2018 with the Achmea judgment, and in 2022 with the Mikula case, there have been more clarification by the European courts. And what I will do in this speech, I will focus on the conflict existing between these two regimes and the recent solution offered by the European courts. And I will explore like 2 points where investor-state arbitrator could interface with EU law and particularly with state aid law. So firstly, what I would like to focus is the fact that in the event that an arbitral tribunal finds that the state has failed its obligation under an investment treaty and awards damages against that specific state, the question arises whether EU law, and particularly EU state aid rules, limit the state ability to abide by such an award. So that's the main question. Can this award is enforceable, can be be executed and give rights to compensation to the investor in that specific case. Secondly, what I would like also to say is very more shortly, because we don't have much time, is the fact that the debate about the compatibility of certain BIT, which is bilateral investment treaties, and especially those between, so the intra-EU, so those between two member states, with the broader EU law obligation of those member states. First of all, a very, very short overview. Most of you are very competent about investor-state aid dispute resolution, but let me just cover it, just to give an introduction. And international investment protection treaties, they do contain reciprocal obligation between two or more signatory states as to the protection of the investment made between the signatory states. And the most prevalent form of investment protection is between two states, the so-called BIT, so the bilateral investment treaty. All the EU member states have BIT with a number of third countries and all with at least one or more EU member states. And these are what we call the intra-EU BIT, which are relevant in today for our panel. I mean, especially for my speech. And a key feature of the investment protection treaties is that they allow investors to have recourse to arbitration and in order to claim damages against the host state in the event of the breach of the obligation under the treaty. And this is, of course, the most important element, because the arbitration can be governed by different rules or institutions, such as the UNCITRAL arbitration rules or the International Chamber of Commerce. However, the majority of investor-state investment disputes are resolved under the auspice of the International Center for Settlement of Investment Dispute, which is called as the ICSID, and is established by the 1966 Washington Convention. And under the ICSID Convention, an award is binding on all parties to the proceedings. And it has to be executed, and we will later see, probably also Professor Ferrari will then go over some of these elements, or I think will be later on in the discussion, because here today I will more focus on ICSID and my colleagues maybe they will more on commercial arbitration. But just to go in the interaction with EU law, and what it's important is that the EU law contains rules identifying and resolving conflict between the obligation of the member state under the EU treaties and those under certain pre-existing instrument of international law. So we have to say that yes, EU law, they recognize also the binding obligation and that member states have taken under international law. This is specifically Article 351 of the treaty, which preserves the obligation owned by the EU member state under the treaties or other agreements predating their accession to the EU. And this is an enshrined, a general principle recognized of public international law that an agreement between two states cannot affect the obligation that those parties may have under prior agreement with third parties. However, there is a question, because EU courts have established that the member state obligation under intra-EU BIT, bilateral investment treaty, they cannot undermine the application of EU law. And based on the principle of the primacy of EU law, the BIT obligation cannot take precedence over any other obligation arising under the EU treaty, including state aid rules. So now, to that extent, I think what is important now is just to focus on the judgment which have been rendered by the EU courts. And I think this is very important because there has been really new case law, and it will have implication in the relationship between arbitration and EU law and the validity of arbitral award. In that context, I recall the famous Achmea judgment of 2018. And in that judgment, the Court of Justice has held that EU law, and particularly specific articles which are related to the judicial system of remedies in the treaty, the European treaty, particularly Article 267 and Article 344 of the treaty, they must be interpreted as precluding a provision contained in an international agreement concluded between two member states, under which an investor from one of the member states may, in the event of a dispute concerning investment in the other member state, bring proceeding against the latter member state before an arbitral tribunal. So that's a simple fact. And that's why that happens. It's just because, in fact, by concluding such an agreement, the member state which are party to it, they agree to remove from the jurisdiction of their own courts, and therefore from the system of judicial remedies, which is recognized by the European Union, specifically by Article 19, the law dispute that may concern the application and the interpretation of EU law. And therefore, such an agreement is capable of preventing those disputes from being resolved in a manner that guarantees the full effectiveness of EU law. So this is the principle, and this has been recently also judges confirmed after the Achmea of 2018 in a judgment of October 2021, which is PL Holdings. But let's just go now, with a few minutes left, just overview the Mikula judgment, which for the Commission, for us, it's really very important. In that judgment, rendered on the 25th of January 2022, the Grand Chamber of the Court of Justice has set aside the judgment of the General Court and has recognized, confirmed the competence of the Commission to assess the arbitration award and the validity of the arbitration award under the article concerning EU state aid rules, which are Article 107 and 108 of the treaty. And it confirmed, the Mikula judgment confirmed the primacy of EU law over intra-EU bilateral investment treaties. And of course, it annulled the judgment, and it confirmed the decision that the Commission had adopted in 2015 on a state aid dispute. So the Commission had adopted a decision declaring that two parties, the Sweden investors, which were Swedish investors in Romania, which had been relying on a BIT between Sweden and Romania, they were awarded by an arbitral tribunal damages after Romania has amended the law which was concerning their investment, and after all they retroactively decided that the investor were not anymore entitled to that money. And the arbitration, which was then started by the Mikula, so the Swedish investor, was based on the fact that Romania had not yet had access to Europe, so it was not yet a member state, and there was the possibility to have valid arbitration under the BIT and under, of course, an arbitration under the ICSID rules. And to that extent, the Commission then decided that the award, the damages that were given to the award to the investors, they were amount to a state aid, which in our European system is prohibited under European law. But what is important, I don't want to go into the detail of the substance, but it's important to just to finish and say that what it was according to the court, the fact that the general court judgment was annulled was based on the fact that an arbitral tribunal before which a dispute is brought is not part of the judicial system. So it's not part of this EU judicial system, which is required and which requires the member state to establish a specific judicial system in fields covered by EU law. So to that extent, the EU judicial system replaces from the accession of the Romania. So once Romania entered the EU, the specific EU judicial system, which is provided under the treaty rules, it had to been replaced, and the dispute that might concern interpretation or application of EU law, they have to be brought under EU courts and not under an arbitration court. And so the arbitration is not a court of the member state within the meaning of the European rule. And secondly, also the arbitral award delivered by the arbitral court is not subject, according to Article 53 and 54 of the Convention, of the ICSID Convention, to any review by the court of a member state as to its compliance to EU law. So that's the point, and then I will really just cut it down. The fact is that the consent, so the main conclusion of this, not only of this judgment, but in the future that we will have to discuss, is that once we have the accession of a member state, the consent that is given by that member state to arbitration and to the ICSID arbitration, it does not originate in a specific agreement reflecting the freely expressed wishes of the parties concerned, but it derives from a treaty which is concluded between two member states, in which those member states have expressly agreed to exclude from the jurisdiction of their own courts disputes that may concern the interpretation or application of EU law. And in those circumstances, and this is from, in this specific case, is from the moment where Romania had access to the EU system and to the EU, the treaty articles, they replaced the arbitration procedures, and thus the consent which was given by Romania from the accession lacked any force. So this is the main conclusion is that the arbitration clause in a BIT concluded between a member state and a third state is capable of adversely affecting the autonomy of EU law after the accession of that third state to the EU, insofar as the BIT is still in force. And as we see, it's actually very, it will have consequences, because it means that any dispute and any arbitration which is brought and which will concern before an arbitral court, which concern two member states, from the moment where those member states are part of the European Union, there is a lack of consent. This is the interpretation of the court, which is followed by the Commission in Brussels, that those parties, they have not consented to the arbitration. Just to conclude, the fact of this will have an impact also on the BIT, as we were saying, the second point I wanted to just cover very quickly was the validity of BIT, which were signed between member states. So it's not that we put into question the validity of the BIT in itself, but what would be a solution, and what the Commission is also trying to have, is that the arbitration clause, which is included in those BIT, should not have any more effect. And in fact, member states, after the adoption by the Court of Justice of the ACMEA judgment, have agreed to just finish and put an end to those BIT, and especially to the arbitration clause. So this will have an impact in the future of arbitration. And I know there is not all the academic world and all the professional do agree with that, but this is at the moment what the European courts have declared, and it will have an impact on the future application of arbitration. And just to conclude, will be the responsibility of the member state? They will have to just, in fact, take, whenever they have an award which is executed before them, they should have either to suspend the proceeding and go to the European Court with a prejudicial question, or they will have to just recognize that there has been no valid consent by the member state. I know this is not agreed for everybody. Also, Professor Ferrari, I know he has his own opinion, but then I finish here. I thank you for the attention, and then it will be Fabienne that will go on with her intervention.
Thank you very much. I have, however, in order to allow everybody to speak, to impose strict time limits. It is not possible to speak for 20 minutes. Okay, please, Fabienne, you have the floor.
Thank you very much. Hello, everybody. If I was told 30 years ago that I would be here doing a conference in front of you, my dear fellows, NYU, I wouldn't have believed it, actually. It's such a great privilege to be here with you today. And even in Zoom, I must say, you all haven't changed. Thank you, Professor Ferrari, for chairing this panel. And thank you to NYU for being such a fantastic university, generating many, many talents. And if I had known that I would be a judge today, I wouldn't have believed it too, because I was supposed to be a lawyer doing business law. And that's how I came to this International Commercial Chamber that I'm chairing together with my two colleagues. I will just give it very short because I have only 10 minutes. So the International Commercial Chamber of Paris, in which I sit as a judge, did not exist 30 years ago. It was created in February 2018, and I was appointed as a judge in this court. And this court is specialized in international arbitration and in international business litigation. Just to mention, as you said, we are all from the 92 class, and my professor of international arbitration at that time was Richard Hulbert, Dick Hulbert, and Professor Harry First, who was my leading professor at the LLM in trade regulation. So that's, I think, those two people made me become a judge in the International Commercial Court, I'm sure. So now I'm ready for the challenge, even if I'm sitting here in front of you today to talk about the French legal system and the arbitration law in France. So long ago, before the creation of the International Commercial Court, the Paris Court of Appeal dealing with international arbitration and the French Cour de Cassation are known for many landmark decisions in the field of international arbitration. And French courts have always been seen over the last 40 years as a very friendly arbitration place. After the New York Convention was ratified, of course, France ratified it immediately in 1959. But we never refer back to the New York Convention in most of our cases because our law is considered as more favorable, even in enforcing arbitration awards in France, than the convention itself. So that's why we refer back usually to the decree of 2018, which enacted most of the case law which was rendered by the French courts. The core of the issue today is international public policy, and under French arbitration law, the basic article is to be found is in Article 1520 of the Code of Civil Procedure. I want to invoke very briefly with you a few questions which our court is regularly confronted with. The issue of public policy requirement for the validity of international arbitral awards is to interpret what is to be considered international public policy. First of all, the ground of international public policy, which is a ground for annulment or a ground for non-recognition, is not, and that is very important, a ground to extend, to analyze the merits of the awards. It's a very strictly regulated control of court judgments based on strict rules listed in the Arbitration Act, and the Cour de Cassation is very regarding to this strict control. One of our recent cases may lead to think that international public policy in France is moving, but as I am sitting in the court, I'm not the one who is going to tell you that our case law is moving, but we are tending, in contrary, to be in accordance with our predecessors. And for instance, international public policy does never extend to any other grounds. Like recently we had a case in April 21 where we refused to annul an award based on the violation based on estoppel. Estoppel is not considered as being under the control, under the public policy criteria. And this is very important. And the court held it in this case that you can see in our internet link. The Court of Appeal in Paris has an internet website, so you can find all the cases on the website. This control of international policy extends to recognition and enforcement as well. It's not only annulment. And under French law, the violation of international public policy has to be manifestly contrary to the criteria, the definition of international public policy. This adverb, manifestly, is very important. And recently, the Cour de Cassation said something that seemed to have a manifestly not so strict as it is, as it has been until now. But this is also not me who is going to say, but more Professor Ferrari, who is going to analyze the French cases if he wants to. So the exequatur of foreign decision is usually granted in France based on the control of a single judge, and the exequatur is almost always granted. Appeal against the exequatur is then submitted to the same strict control than the annulment of awards. So just to go quickly, because now time is running, with respect to violation of public policy, we use red flags. And we consider that only red flags which are significant, specific, and concordant may be considered as a criteria for recognition of violation of public policy. And the rule, the judge applies these rules very strictly. You will see in recent cases, September 7, 2021, the Republic of Guinea versus Global Voice, and another case, Airbus versus Samuel. The court held that it results from the control by the arbitral tribunal, as it was entitled to do so, that the actions do not characterize significant, specific, and concordant indicators. And we didn't consider that international public policy was violated. And we considered that the corruption which was alleged was not sufficiently established so that we could annul eventually the award. our control is a sort of a hybrid control, like hybrid cars, you know, we use gas and then we also use electricity. No, that's true. I mean, we use always a sort of a balance between the extent of our control and the notion and the criteria of international public policy. And in our latest case law of Cour de Cassation 23 of March 2022, the Cour de Cassation opened a little bit the control to characterized violation of international public policy. What is characterized violation? More than manifestly contrary to public policy? That's the future is going to tell us. Under French law, we have mandatory law that is not necessarily considered international public policy. But the Paris Court of Appeal considers that only French mandatory law that is necessary for the protection of public interests, that is vital for the French political, social, or economic organization, is to be considered as international public policy. But French public policy is not necessarily international public policy. And that's very important to keep in mind, because here we are in international arbitration and not internal arbitration. The last thing I want to tell you is in France, usually a foreign award which is annulled in the country of origin is not necessarily annulled under French law. There is a clear line of French case law permitting courts to recognize and enforce awards which have been set aside in the country of origin. For instance, the Norcelor case or Hill-Marton or Putra-Bali, which are our landmark cases on this, allow an arbitral award to be enforced in France, and they are considered as equally positioned to be recognized and enforced. And only then the court applies its own criteria for international public policy. Last thing is the inconciliability between two decisions. Foreign award, when it is enforced, is considered as the same force as a state court judgment, only if it's with exequatur. And this is a rule that we apply very strictly. If an award, an international award, has been exequatured before the court is seized of the award, there is a risk of inconciliability that we take into account. And this is very important to keep in mind, because France recognizes awards in any event and gives a full force to the exequatur which is given to a foreign award. My conclusion is very quick to say that with the United States, we have been confronted with an anti-suit injunction given against an Italian lawyer who won an award against an American company. And he had the award annulled in the United States, but it was not annulled in France. And the US gave an anti-suit injunction to this Italian lawyer who was then condemned for contempt of court against the US. And this is the end of my 10 minutes. So I had a minuteur, you see. Thank you, Professor Ferrari. Thank you to all of us. And I'm open for discussion in a few minutes if you want to go further in all this presentation. Thank you.
So thank you very much. Now, after Alessandra very clearly stated the law in relation to EU law and investment arbitration, and you, Fabienne, dealt with French law, I will actually address Article 5.2b of the New York Convention, which, as we all know, allows states to refuse recognition and enforcement of arbitral award if recognition and enforcement would be contrary to the public policy of that state. And you will see why I refer to that state specifically. From the text, in my opinion, it is clear that the public policy exception in Article 5.2b has the effect of subjecting, and here I'm referring to subjecting only the arbitral proceedings to a specific form of ex post control. The very existence of this ex post control has contributed, in my opinion, to the liberalization of the law on arbitrability. Why? Since it is possible to review whether an individual award breaches public policy at the enforcement stage, it is therefore not necessary anymore to a priori exclude many disputes from those capable of being resolved by arbitration. This is where the effect comes in. The Mitsubishi decision by the US Supreme Court famously endorsed this shift from ex ante to ex post control. Now, while the existence of a public policy exception in the framework on arbitration is certainly useful, such ex post control is not without risk, because it seems that it is abused. In effect, as stated, for example, by the Hong Court of First Instance in 2009, and here I'm basically quoting, public policy is often invoked by a losing party in an attempt to manipulate an enforcing court into reopening matters which have been, or ought to have been, determined in arbitration. The public policy ground is thereby raised to frustrate or delay the winning party from enjoying the fruits of a victory. The court must be vigilant that the public policy exception is not abused. And I'm still quoting from the words of the Hong Kong court. The dangers referred to arise because of the lack of definition of the concept of public policy. Now, as stated by a different court, the Caribbean Court of Justice in 2013, the concept of public policy is fluid, open-textured, encompassing potentially a wide variety of acts. It is conditioned by time and place, religion and morality, as well as fundamental economic, social, political, legal, or foreign affairs of the state in which enforcement is sought. Now, this lack of definition has pushed commentators to suggest that recognition and enforcement be refused only if the public policy raised is a so-called translational one, meaning, to use the words of the Court of Milan, Court of First Instance, a body of universal principles shared by nations of the same civilization, aiming at the protection of fundamental human rights, often embodied in international declarations or even conventions. Now, in my opinion, this definition disregards the text of the New York Convention, which clearly, as I mentioned earlier, refers to the public policy of that state, meaning the recognition and enforcement court's state. This does not mean that one should advocate to compare the New York Convention's concept of public policy with comparable concept of that state elaborated with a view towards purely domestic situations. No, this is not what I'm suggesting. Rather, however, the concept of public policy the Convention refers to is one the outer boundaries of which must be identified autonomously in light of the Convention itself, as required by the rules of interpretation of treaties. Now, this means, for example, that it must have relevance for a given society as a whole. That's one of the elements to take into account. Case law shows that courts have used different terminology to describe the public element, of course, of Article 5(2)(b) on public policy. Now, for example, courts have referred to just give a few examples, the forum state most basic notions of morality and justice. To give another example, a grave defect which affects the foundations of public and economic life. Or to give one more, instances where the upholding of an arbitral award would shock the conscience, was clearly injurious to the public good or wholly offensive to the ordinary, reasonable, and fully informed member of public, or would violate the forum state most basic notions of morality and justice. Now, these are just a few examples, more could be given. Now, the context of Article 5(2)(b) also supports the proposition that the public policy exception must be construed narrowly. Thus, it would be, in my opinion, systematically inconsistent to interpret Article 5 to be as a broad, let's call it, catch-all provision to refuse recognition and enforcement. That is not possible. And actually, case law has endorsed a narrow interpretation of public policy. And I know this is true in many countries. The decision of the Court of Appeals for the Second Circuit in Parsons, Whitmore overseas v. Société Générale de l'Industrie Papier, RACTA, and Bank of America stands, in my opinion, as a prominent example. There, the court, and we're talking about the Second Circuit, the court stated that the convention's public policy defense should be construed narrowly. To read the public policy defense as a parochial device protective of national political interests would seriously undermine, of course, the convention's utility. This means, among other things, that there has to be a higher standard, that a higher standard should apply in relation to the refusal to recognize and enforce foreign awards as opposed to domestic awards. Such a distinction between applicable standards for refusal in domestic arbitrations versus certain standards to be used in international arbitrations can, for example, be found in a ruling by the Swiss Federal Supreme Court, which held not too long ago that being an exception, the public policy reservation is to be interpreted, yes, restrictively, especially in respect of the recognition and enforcement of foreign decisions, where its scope is narrower than in respect of the direct application of foreign law. This is what they call the attenuated effect of public policy, effet atténué de l'ordre public. Now, similarly, in October 2021, the Court of Appeal of Koblenz in Germany held, in line with the German Supreme Court that had stated similarly in different occasions, that public policy precludes the recognition and enforcement of an award in Germany if its recognition or enforcement leads to a result that is manifestly incompatible with fundamental principles, of course, of German law. And here the word manifest is the one Fabienne used earlier, even in France. Now, this is a case, and I'm quoting from that decision, if the arbitral award violates the norms that regulates the foundations of state or economic life, or if it is in intolerable conflict with German concept of justice. If, as in that specific case, a decision has to be made on the recognition and enforceability of a foreign arbitral award, in the interest of international trade, the standard, and this is the important part, the standard of review of international public policy applies, which is less strict compared to the domestic public policy standard. So this is exactly what needs to be said here. Of course, importantly, and here I'm talking or referring to something Alessandro said, the domestic public policy for international situations may, of course, be influenced by European law. This is, however, not something I want to focus on. Thank you very much. And this being said, I give the floor to Fabio.
Thank you, Professor Ferrari. Thank you all for being here with us. And if you stayed, you're courageous. It is my pleasure to address a few words on Luxembourg. I am a practicing attorney in Luxembourg. After graduating from NYU in '92, I went on with my practice in Luxembourg, where I practiced mainly as a litigator. And in this capacity, I encounter quite a lot of enforcement of arbitral awards, international arbitral awards in Luxembourg. Why? Because Luxembourg, of course, is a financial place. It has, of course, you can find many assets, and therefore it is a place where you would look at if you want to enforce an arbitral award, which of course you cannot enforce in the country where usually you have obtained it, or if it's, for example, a state arbitration, then you would not enforce it in the state against whom awards have been ordered compensation. So what to highlight the differences of the Luxembourg legal system. First of all, Luxembourg has a legal system which is mainly based on French law. It is mainly based on Code Napoleon. So you can find very much a very similar approach, if not sometimes identical. But there are some slight differences, of course. And in this framework, how does the Luxembourg legal system review the conformity of a decision through the prism of international public policy? That's what we want to address today. First of all, it is Article 1251 of the Code of Civil Procedure, which regulates the matter. And it of course, triggers an exclusion of its own rules if Luxembourg is a party of an applicable international convention. Now, of course, this degree of control, which is allowed to the Luxembourg courts on the basis of the international convention, is an infinitely narrower concept than the one of domestic public policy. Now, if we remain in the framework of the New York Convention, which is, of course, the main convention on commercial arbitration, it deals with the recognition and enforcement of arbitral awards, to which, of course, Luxembourg is a party. Luxembourg, therefore, case law consistently establishes that as soon as the enforcement of a foreign arbitral award is governed by the New York Convention, the specific rules of Luxembourg law do not apply. In Luxembourg, refusing to enforce an award rendered in a state which is a party to the New York Convention for violation of public policy will therefore be assessed according to Article 5.2b. And however, since the New York Convention does not itself provide with a definition of public policy, we go back to the state to define it, and therefore it will be defined by Luxembourg law. The definition of international public policy under national law or under the New York Convention is therefore, at least in Luxembourg, completely equivalent. Now, what is a positive definition given by the Luxembourg courts of international public policy? First of all, let's cite a scholar who mainly all agree to say that for some years now, there has been a positive definition of public policy, contrary to the casuistic approach with which the French Cour de Cassation is quite comfortable with. Now, that is one of the first differences with the French Cour de Cassation. Let's take a Luxembourg definition from a very recent decision. The exclusion of enforcement on the grounds of public policy is justified only in the case of infringement of a fundamental principle of the legal order of the requested state by the violation of an essential rule of law or a fundamental right in the legal order of that state. Now, by bringing together the various principles that we can derive from case law and doctrine on recognition, it appears that the violation of Luxembourg public policy is characterized when the enforcement of the award is either unacceptably offending the legal order of the requested state by infringing a fundamental principle. That's a decision by 2013. And these principles are recognized as fundamental by domestic law or also by European or international law. European, for example, on the Convention of Human Rights. So, secondly, it clearly also needs to violate a rule of law which is considered essential in the Luxembourg legal order, or it infringes a fundamental right of that legal order. And that is also cited by a very recent decisions. Now, these are rules and principles which, without necessarily having been elevated to the rank of fundamental rights, do constitute essential rules or fundamental principles of the Luxembourg legal order. Now, Luxembourg doctrine and case law agree that even a gross error of fact or law, if committed by the arbitral tribunal, is not a ground for refusing to enforce the award. That seems to be accepted internationally. Now, in a very recent decision, the Court of Appeals of Luxembourg said that notably it stated principles and sources of international public policy also in other forums and in Luxembourg. So there is this principle that you will take into account what happens in other systems. Now, for the implementation of the public policy exception, by a court, when analyzing awards or decisions, when restricted by some consideration. First of all, the exequatur judge does not verify the conformity of the award with domestic public policy, but the effects that the recognition of this award would have on public policy. And this is known, at least in Luxembourg, as also the attenuated effect of public policy. And the overall convergence of foreign law with Luxembourg law also limits the judge's appreciation. The Luxembourg judge will restrict its supervision over the effects of the decision because it was rendered by courts of other states having similar laws and public policy. Now, of course, EU member states would all qualify, and most probably all the nations which have the rule of law at their heart. Now, most notably, this assessment will also apply to the review of arbitral awards by member states' courts. Now, this is, in a very short nutshell, the position in Luxembourg. Luxembourg, which is indeed, and that might be one takeaway, a very friendly jurisdiction for the enforcement of arbitral awards or foreign judgments by all means. And as long as those awards will respect the fundamental rights, the fundamental due process rights, they will be enforced, they will not be reviewed. There is one other exception I wanted to underline with the French Cour de Cassation. In a very recent decision we obtained in 2017, contrary to the Cour de Cassation, if, however, the award is annulled or set aside in the place where it has been rendered, then our jurisdictions will refuse its enforcement. That might be a big difference because it is indeed a position which is not shared by the French jurisdictions. Thank you very much for listening up to now. And of course, if you have questions, it would be a pleasure to participate in the discussion.
So thank you very much, of course, Fabio. So allow me to ask a few questions, Alessandra. You, of course, as the expert on the relationship you have outlined, okay? So you will refer to European law, its impact on investment arbitration. So allow me to ask a policy question. Here again, your private view, what do you think? Will EU courts try to have an impact also on commercial arbitration? Or do you see that European courts will keep their hands off this, or is it a field where they will try to have an impact as well?
Well, there are two perspectives from the point of procedural rights. Even the Mikula case, specifically in the judgment, the Court of Justice has differentiated the ICSID arbitration with the commercial arbitration. So, and especially with regard to the validity of the arbitration clause, just because of a difference, because it's by stating that in the specific the arbitration clause was included in the BIT, so it was not expressly given the consent by the parties, and that in specifying that differences is mentioned that this is different in commercial arbitration, whereas maybe you will really have a specific consent which is expressly given by the party. So that's already a difference, because one of the problems was the fact that we cannot say that there is a consent, the consent given in BIT for the Court of Justice per se was not valid. Then on the overall problem of primacy of EU law, I must say that there is the tendencies to consider that in a broader sense, arbitration, as is not allowed to, arbitrators are not allowed to refer any case under the treaty, so specifically is Article 267, to the Court of Justice for the interpretation and the application of EU law. There might be also issues of incompatibility application of EU law, and there might be also the issue of the same issue which we just mentioned for the ICSID for the commercial arbitration. So far, it did not went so far the court, but we had some the EcoSuisse, we had some cases where the boundaries are already set. So the issues that the arbitrator has to be bound by EU law. So to a certain extent, they have to consider that there is also EU law, and there is not has to be violation of what we consider the principle of privacy. So There is not yet
No.
something held, but there might be, unless the arbitrators, they do keep on applying EU law.
Now you see why she is an expert, of course. So thank you very much for your reply. And Fabienne, allow me to ask you also a question. So you made it very clear at the beginning of your presentation that you would talk about French law. Why? Because basically in France, courts use French law, even for recognition and enforcement purposes, not the New York Convention, because actually the New York Convention, Article 7, allows courts to do that if the arbitration law is, of course, more recognition and enforcement friendly. From your talk, I get, however, the idea that we're getting to the same result. So I referred in my talk, of course, to Article 5.2b. I hope that more legal systems will draw the line, which, if I'm not mistaken, you in France have already drawn, meaning make a distinction between public policy for purely domestic cases and public policy that is still national public, but for international cases. Am I right, Fabienne?
I'm just turning my microphone. Yes, Franco, thank you for this question. Well, as I am sitting in the court, which is in charge of making decisions on cases, I cannot say as a principle that the case law today is going to be the same as tomorrow and as the day after tomorrow. But yes, you're absolutely right. As of today, I would say that before the decree of 2011, the case law, the French courts were really trying to set a legal frame that is totally arbitration friendly, meaning the principle of competence that are, that we recognize that only the arbitral tribunal is competent to decide on its own competence. The rule also that arbitral awards shall be recognized and enforced by a single judge ex parte without any discussion, meaning that that arbitration awards are part of the legal set of decisions in France. The thing is that Professor Gaillard, unfortunately, who died last year, was very important in the creation of the legal order in France, but also other very important judges who sat in the Cour de Cassation, Professor Ancel, the Judge Acquaviva. All these judges have created a case law that, as in common law, is very predictable, and we want to be predictable, and that's the most important. If you come to a French court, you are supposed to know that you are in front of arbitration-friendly courts, and it's just on the side that it may move a little bit, but the core stays.
So one last question, we have 2 more minutes to Fabio. Fabio, you did in fact point out a difference between the case law in Luxembourg vis-a-vis the case law in France on a very important issue, meaning the issue of enforcement, or actually in Luxembourg, non-enforcement of arbitral awards annulled in countries of origin. Now, I have to say statistics show that the Luxembourg position is the one adopted more often than not, I have to say. I'm talking from the US. I say that because here in the US, courts have now, of course, also enforced arbitral awards that were annulled in the country of origin, but on different grounds. So while the French look not at the annulment decision in the country of origin and use through Article 7 of the New York Convention domestic law to actually recognize and enforce it, in the US, courts target, as far as the analysis goes, target with their analysis the decisions that were the annulment decisions in the country of origin. So it's a different approach. We get in part to similar outcomes, not always. Has there been any doubt in this respect, Fabio, or you say, no, this is Luxembourg case law it will not change. There was never any doubt on this.
No. I think we cannot say that. The decision is of 2017. It was the first time that exactly on this issue there was a decision, and the decision was took some time to come out. So I think I can say there was some hesitation on the part of the court, and since then the Court of Appeals did not have a chance to pronounce itself again on a similar case. So by all means, it could change, even if, of course, this decision is there. It's well motivated, but for reasons linked to the case, it did not go to the Cour de Cassation. So it might as well evolve. Yes, it would not be the first time that we see an evolution in the jurisprudence. So who knows? Future will tell.
So this is exactly what we should get out of this. The concept of public policy is always evolving. It depends on where it is looked at what stage, and so forth. This being said, I thank actually Alessandra, who contacted me first, then of course Fabienne and Fabio for putting this together, for allowing me to be part of this NYU Reunion 2022 webinar. I would have preferred to see you in person, okay, but next time, in 10 years, or in 5 years, or hopefully, even before in any other place. I thank you very much. I thank the attendees for this, and I hope to see you soon. Thank you, and most importantly, stay safe.
Thank you. Bye-bye. Thank you.
Thank you.
Thank you to all. Thank you to all who participated.